So we need to talk about what is now an important bench trial that just took place in a rifle and magazine ban case. So let's break down what just happened. Now really quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support the channel for free, a free way to do that is of course just subscribing, and then just double check to make sure YouTube has not unsubscribed you because they do that all the time. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases which challenge the state of Illinois and their ban on so-called assault weapons, and then also their magazine ban where they simply are banning magazines that hold more than 10 rounds. Last week, a very important bench trial took place in multiple consolidated cases which challenged the state of Illinois and their various rifle bans, their magazine ban, and the new laws that they put in place through the Protect Illinois Communities Act, also known as PICA. This all comes off the heels of a recent Supreme Court order which denied emergency review in a bunch of these cases because the Supreme Court wants a final merits decision before they actually address the issue of rifle bans and magazine bans. Well, a bench trial recently took place in the state of Illinois in a federal court in front of a district court judge, Judge McGlynn, and it's going to lead to a final merits decision. Now, you might remember that originally in multiple lawsuits, district court judges issued preliminary injunctions which intended to halt the enforcement of PICA. There were multiple judges in various cases which were filed which challenged this law. There were lawsuits from organizations like GOA, FBC, I believe, NAGR. So there were a ton of lawsuits which have now been consolidated and have been heard by Judge McGlynn. Now, originally on reviewing some of these cases, Judge McGlynn outlined how he believed that the plaintiffs were likely to succeed on the merits of their claims that the Illinois rifle magazine ban did in fact violate the Second Amendment. However, the state of Illinois then appealed the granting of that preliminary injunction up to the Seventh Circuit, and on review, a liberal and biased three-judge panel in the Seventh Circuit overruled the granting of that preliminary injunction. Instead, this liberal Seventh Circuit panel concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they use something known as the military use test, which does not align at all with Supreme Court precedent. Then there were multiple requests for en banc panel review in the Seventh Circuit, but the Seventh Circuit en banc panel at large did not want to review any of these cases, so multiple lawsuits were denied review by the Seventh Circuit en banc panel. Then that led to multiple cases then seeking immediate Supreme Court intervention, but like I mentioned, the Supreme Court at the end of their last term denied review to a bunch of Illinois cases that were seeking emergency review. Now, in the denial of all those emergency reviews, Justice Thomas did make a statement for the court, and he stated that the state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. He stated that the AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. In my view, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. He then concluded by saying that the Supreme Court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied review to these Illinois cases, Justice Thomas did make a strong statement showing that the court does have interest in reviewing this issue, that they want a final merits case, and if the Seventh Circuit ultimately concludes that the state of Illinois can just outright ban these types of rifles, well then many of the justices, including Justice Thomas, will want to review this issue. But in all reality, we know that some of these lower courts will not listen to the Supreme Court, and they will reach the conclusion that they want, that the state like Illinois can just ban these rifles and magazines. Now, while all this was still going on at the Supreme Court level, the lower court judge, Judge McGlynn, had decided to move all these cases along towards a final merits decision. Now, last week, we had a multi-day bench trial that took place in front of Judge McGlynn in multiple Illinois PICA cases. Now, the discussions at the hearing varied from the distinctions between the military M4s and other types of military rifles that are used by the Army and the Navy and just the military at large. And then there was a discussion about what distinctions are there between those types of rifles and then the civilian class AR-15s, which are being banned by the state of Illinois. So there was a lot of technical discussion about the rifles in question. How do they differ from the ones used in the military? They talked about the ones in the military being sometimes burst fire, sometimes automatic as well, and how these civilian rifles are simply semi-automatic. And then there was a lot of discussion about what utility are these types of rifles. Are they used in self-defense? How often are they used in self-defense and things like that? And then at one point, there was also even a witness from the state, and the witness from the state even admitted that he has an AR-15 and he has the magazines in question that are being banned by the state of Illinois. And he even stated that he does not want the state of Illinois to ban the items that he also has. Now, also at the end of the hearings, there was a lot of discussion from Judge McGlynn about the historical support for these types of restrictions, just outright banning these types of rifles. Judge McGlynn himself also brought up some historical evidence and some discussion about some historical riots, I believe in 1917. He believed that there were a ton of atrocities that maybe could have been mitigated by the individuals in question having these types of rifles. He mentioned that there were atrocities in the riots against, I believe, the African-American community in the St. Louis area, I believe, and that there were a ton of houses burned down, and maybe that they could have protected their community if they had these types of rifles. So that was pretty based of Judge McGlynn mentioning that, hey, maybe these individuals could have fought off these atrocities if they had AR-15s. Now, at the end of the multi-day hearing, Judge McGlynn ordered all the parties to file additional briefs on the historical support and evidence related to these types of rifles and the various restrictions that maybe were in place historically for these types of rifle bans and these accessory bans and the magazine bans. Because also remember, there was some discussion during the hearings about the various characteristics which are being banned by the state of Illinois. Because remember, in PICA, there are threaded barrel restrictions, there are pistol grip restrictions, detachable magazine restrictions, telescoping stocks restrictions, and a lot of other things that the state of Illinois is trying to ban as far as characteristics. So additional support needs to be provided by all the parties about the constitutionality of even the characteristic bans. So that's what's going on in Illinois. The lower court has heard arguments in a bunch of these consolidated cases, and now the last important briefs will be submitted shortly. Judge McGlynn ordered that they be filed within 30 days. So on October 21st, those briefs will be submitted to Judge McGlynn, and then we will be waiting for his decision. Now, my gut feeling, of course, coming out of Judge McGlynn and listening to the arguments and seeing some of the discussion about the arguments, I think Judge McGlynn, no doubt, will strike down the Illinois restrictions once again. He seems pretty pro 2A. He's brought up historical supports and historical issues related to these types of just comprehensive rifle bans. So I think he will ultimately strike down the Illinois rifle magazine ban once again. He seems like he's leaning pro 2A, but no doubt what will happen is that the state of Illinois will then appeal once again to the 7th Circuit. And depending on the panel in the 7th Circuit, I would anticipate that they will uphold the rifle ban, and then this will eventually make its way back to Supreme Court if another case like the Bianchi case out of Maryland doesn't get decided and reviewed by the Supreme Court first. So that's where this currently stands. I know a lot of you guys in Illinois who watch the channel wanted an update of what happened during those hearings. That's what happened, and that's where this case goes from here. So if you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.